Equal child custody in Utah. More common, increasingly favored, but still not presumed. One of the most common misconceptions I hear from parents is this: Utah is automatically an equal custody state now. People say it with tremendous confidence, and honestly, I understand why. Equal parent time is far more common in Utah than it was 20 or 30 years ago. Utah has statutory equal parent time proposed schedules, not mandatory, but guidelines. Many judges increasingly view substantial involvement by both parents as beneficial to children, as well they should. It's long past due. Social attitudes have shifted heavily toward shared parenting, but none of that changes an important legal reality. Utah does not currently have a statutory presumption of equal physical child custody. Not now, not historically. Utah law does recognize a rebuttable presumption favoring joint legal custody in many situations, but legal custody and physical custody are not the same thing. Legal custody concerns decision-making authority over issues like child education, health care, and religion, things of that nature. Physical custody concerns where the child actually lives and how overnights are allocated between parents. Utah's Equal Parent Time statute, Utah Code Section 81-9-305, does not provide that courts must award equal custody. It says instead that courts may award equal parent time if certain findings are made. That word "may" matters. Courts are still required to conduct a best interest analysis. They look at issues like parental involvement, logistics, communication, and whether equal parent time is actually workable for the child or children. Now, having said all that, I think Utah is gradually evolving towards some form of rebuttable presumption favoring equal physical custody in many, if not most, cases. Frankly, I think it should. If two fit parents are equally capable of caring for their children, and that's a low standard, being capable, there is a strong argument that children generally benefit from meaningful relationships with both parents unless a preponderance of evidence shows otherwise. Historically, custody law openly favored mothers under what became known as the Tender Years Doctrine. Formally, that doctrine is gone, but I think remnants of that mindset still linger culturally and institutionally. Not as openly before, not as crudely as before, but they linger. Many fathers still walk into court feeling they must prove worthy of maintaining equal custody of children they already helped raise every day before the divorce action was filed. At the same time, people should avoid swinging too far in the opposite direction. Equal custody is not automatically appropriate in every case. Domestic violence, abuse, neglect, severe instability, substance abuse, or serious practical barriers may absolutely justify unequal parent time. So the real takeaway is this: Utah does not currently have an automatic custody formula, but equal parent time is increasingly common, increasingly accepted, and increasingly viewed as a legitimate arrangement in many cases. The strongest custody cases are still the same as they have always been: evidence-driven, child-focused, practical, and credible, not ideological, not performative, and not dependent on internet slogans like "Utah is automatically a 50-50 state now."